Hi, my name is Elizabeth Blandon, representing the law firm of Blandon Law. We are a boutique immigration firm based in Weston, Florida, representing clients all over the United States. I'm here to talk today about asylum. Asylum is when a person is in the United States and applies for protection because if they're returned to their home country, they will suffer significant harm. Today's topic is about whether a person can be detained when they go for their asylum interview. And the reason I want to talk about that is because we've had a client who's been very much in the news. He is Venezuelan political activist Marco Coello, and he was detained when he went to his asylum interview at the Miami Asylum Office on April 26, 2017. Fortunately, he was released the very next day, but still what he had to endure is not the norm. And I'm here to explain why. Basically, there's two types of filing asylum. One is when you enter the United States legally, or even if you don't enter legally, you file on your own with immigration, usually within the first year that you enter the United States. You send an application and you mail it to immigration. That is known as an affirmative filing. That is what Mr. Coello did. The other process is when you are in deportation proceedings, actually known as removal proceedings, and then your case is in front of an immigration judge. The reason that's different is because what you do at that point, what a client will do is you'll file asylum as a defense to being deported. That's why it's called defensive asylum filing. That's very different. Now, importantly, the entire removal proceedings starts not when a notice to appear is mailed to a foreigner, but when it's actually filed with the court. Not every person who's in the United States without authorization is put into removal proceedings. That's a decision that's made by attorneys who are then going to have to argue that case in court. They know that there's some cases that are not worth arguing, and so they never file the notice to appear in court. So what I want to make sure that everyone's very clear about is that just because you file an affirmative application with immigration, that does not mean that you're going to be detained. In fact, that is not the normal process. That is not what normally happens. The normal process is that a person will file an application with immigration, and about 3.5 to 4 years later, you will, depending on where you live in the United States, you will be called to an interview at your nearest asylum office. The interview will proceed. You will be allowed the opportunity to present your evidence. They will ask you questions about your claim to determine whether or not they believe you will suffer harm if you return to your home country. Then you'll get a decision. If your case is approved, you're going to be known as an asylee, and a year later you can apply for residency. But even if your case is denied, what happens then is you are referred to immigration court, and then someone determines whether or not to hear your case in immigration court. There are clients that I have whose asylum cases have been denied, and they have never been referred to court. They have never had to go to court. So it's important to understand that what happened to Mr. Coello is extremely out of the norm. Please keep reading up about his case because there's a lot more that's going to be happening. But I just want you to rest easy and know that that is not the normal process. And if you believe you will be harmed in your home country, please see an immigration attorney who is experienced in asylum matters. Also, please read our free ebook available on our website in both Spanish and English about asylum process. We are here to protect and inform, and if you are a client of Blandon Law, I look forward to opening the door to your success.